In that hearing, the committee raised its areas of concern as well as the areas which it was satisfied with, and then drew up its concluding observations. During the 54th optional procedure adopted in its 38th session, the committee adopted a list of issues which was then conveyed to the State of Cameroon, which has provided its answers to those questions. These answers are the basis of the 5th periodic report, and thus Cameroon now has an opportunity to hear the committee's assessment and can also inform the committee for that purpose of the various measures it's taken to fight against torture, cruel, inhuman, degrading treatment or punishment, as well as in order to follow up on the recommendations made by the committee concerning the preservation of physical and moral integrity. Chair, honourable members, the report which I now present to your august institution covers the period between 2010 and 2015, but we can give you up-to-date information whenever necessary. We had a participatory approach in drafting it with the contribution of various public bodies as well as financial and technical partners and civil society organisations. This report takes stock of the definition of torture in domestic law as well as fundamental legal safeguards in the area of deprivation of freedom and the guarantees of independence of the National Commission of Human Rights and Freedoms, the fight against harmful practices, the fight against violence against women, and to fight maternal and child mortality, prison conditions, and training to prevent torture. Cameroonian delegation welcomes the attention that the committee will address to our answers to your concerns. Chair, honourable members, since we came before you last time, the State of Cameroon has been unwavering in its proactive policy to promote and protect human rights, which continue to be one of the structuring values of national policies, of which the zenith is the strategy document for growth and employment. In this policy, the fight against all attacks on people's physical and moral integrity, and notably against all forms of torture and cruel, inhuman and degrading treatment, play a significant role. This concern is all the more topical since the state's efforts have been deployed in a context which has been characterised by a range of incidents which can affect the life and physical integrity of people, including the attacks of the Boko Haram terrorist group, the worrying humanitarian situation, and social tension linked to the demands of certain professional bodies in northwest and southwest regions. With this in mind, one of the state's strategic choices to keep human rights as the moral backbone of all its actions was the adoption of the National Action Plan to promote and protect human rights in 2015, covering the period 2015 to 2019. One of the cornerstones of this is the defence of life, physical and moral integrity, which are absolute and sacred values, and no attack on them will be tolerated. Our major concerns have been taken into consideration by the National Action Plan. In order to translate them into facts, our state has taken legislative, institutional, judicial and regulatory reform with a view to enhancing the protection of human rights. On the legislative plan, the legal framework fighting torture and other attacks on people's life and integrity has been strengthened, and I would like to highlight the following: the ratification of the United Nations optional protocol to the Convention on the Rights of the Child concerning the involvement of children in armed conflicts. This was on the 4th of February 2013. We also ratified the Organisation of African Unity's Convention on Prevention and Combating of Terrorism, which was ratified on the 31st December 2014, and we have also acceded to the African Union Convention on Protection and Assistance of Internally Displaced Persons in Africa. This was by a decree on the 31st of December 2014. We adopted Act 2016/007, establishing a criminal code. This strengthens the protection of people's physical and moral integrity, particularly that of women and children, by criminalising new offences such as female genital mutilation, breast ironing, through the criminalisation of the offence of delaying the early development of breasts, sexual harassment, early and forced marriages, and this is when any marriage involves spouses who have not yet reached the age of 18, human smuggling and trafficking, preventing torture and impunity by extending the range of perpetrators of such acts to include traditional authorities. We've also adopted Act 2014/028 of the 23rd of December 2014, which is a counter-terrorism act in strict accordance with United Nations resolutions on the issue. We also adopted Act 2017/012 of the 12th of July 2017, which establishes a code of military justice, which provides military courts with jurisdiction for punishing serious crimes such as war crimes, crimes against humanity and genocide. On the institutional front, our measures include the ordinance of the 16th February 2016 to establish the Compensations Committee when there's been wrongful detention or policed custody. We also created the National Committee to Fighting Child Labour through a decree of the 27th of August 2014, and we've set up call centres and gender decks in police stations for supporting and guiding women who've been victims of violence. And we created an interministerial committee tasked with managing the refugee crisis in Cameroon through a decree of 13th of March 2014. This aims to ensure coordinated management of the humanitarian emergency caused by the massive displacement of populations as a result of insecure borders and the atrocities of Boko Haram. On the legal judicial front, a number of decisions have been taken to punish attacks on people's physical integrity. These decisions have been handed down by courts throughout the country, and this reflects the positive impact of training for judicial officials. Chair, honourable members of the committee, policies, programmes and projects have underpinned the state's activities to provide an appropriate environment for protecting people's physical and moral integrity. In this regard, I'd like to mention the adoption of the National Gender Policy and National Action Plan for eradicating the worst forms of child labour in Cameroon, updating the national strategy to fight gender-based violence, as well as the National Plan of Action for eradicating female genital mutilation. Furthermore, we have a plan of action for the health of detainees. This was drawn up in 2017 in order to speed up ongoing reform of health conditions in prisons. These efforts have been combined with training for law enforcement agencies and members of the judiciary and prison staff. Chair, honourable members of the committee, these meritorious efforts of Cameroon have come up against a security environment characterised by the fight against terrorism and a worrying humanitarian situation, as well as social tension, which has destabilised certain regions in the country. In fact, since 2013, Cameroon has faced the atrocities of the Boko Haram terrorist group. Its repeated acts have led to the loss of over 2,000 lives, abductions, destruction of property, and the use of children as human shields, soldiers, or sexual objects. This climate, together with the security situation in neighbouring countries such as the Central African Republic and Nigeria, has caused a massive influx of refugees and displaced persons into Cameroon, with the corresponding burden of looking after them. Chair, members of the committee, in order to respond to this plethora of challenges, the state has taken a number of measures to strengthen its implementation of its international commitments. Thus, in our fight against the Boko Haram group, Cameroon has followed the World Strategy to Fight Terrorism. With this in mind, respect for fundamental rights continues to be one of the cornerstones of our actions. training of defence and security forces in respect for human rights, and the punishments handed down to members of these forces, and to prosecute the perpetrators of terrorism epitomises our attitude. Legal punishments as well as administrative and disciplinary measures have been handed down against the members of the defence forces who have violated human rights. When it comes to prosecuting the perpetrators of acts of terrorism, we respect the rules of a fair trial, and there are no group convictions. Nevertheless, this has triggered new challenges, notably in managing our prison population, which has increased considerably. Marua Central Prison has a capacity of 300, but in July of this year it had 1,525 inmates, 708 of whom had links to Boko Haram. In order to correct this situation, in spite of budgetary constraints, the state is refurbishing this prison in order to bring it up to standard. When it comes to protecting refugees, on the 31st of August of this year, Cameroon had 626,681 refugees, as well as 237,966 IDPs. There are a number of challenges linked to taking care of them, in addition to the institutional measures which I've already referred to. A refugee management plan was adopted in 2016, even though the implementation of that plan is constrained by the need to raise the necessary funds for it. When it comes to social tension, the demands of certain professional bodies, of teachers and lawyers in the English-speaking regions of the northwest and southwest have been felt, whilst the state tried to engage in dialogue and took a number of structural and pragmatic measures to provide solutions. These claims have spilled over onto the political front with violent demands for secession from Cameroon. Thus, in the demonstrations of 22nd November and 8th of December, acts of vandalism and violence against public property and people occurred, and thus the security forces were forced to intervene to restore order. Those arrested have been brought before Yaoundé military court, and certain proceedings, though, have been dropped on the orders of the head of state. Furthermore, on the 1st of October, in the name of a supposed declaration of independence of the aforementioned regions, armed groups carried out attacks against institutions, jeopardising territorial integrity, and also they attacked law enforcement agencies. Thus, force was needed to restore order and to preserve people security and to protect property. In any case, inquiries have been launched in order to shed light on this matter and to bring the perpetrators to justice using a fair trial. Chair, honourable members of the committee, special attention has been attached to the rights of certain groups. In this context, violence against women, harmful cultural practices such as FGM, breast ironing and child marriage are now criminalised under the criminal code. We have raised awareness against these scourges, notably through the national launch of the African Union campaign to curb child marriage, and victim shelters have been set up, as well as local committees to fight these practices in the areas where they're most prevalent. Chair, honourable members of the committee, as you can see, the promotion and protection of human rights are a constant concern of the Cameroonian government, despite a particularly difficult social and economic climate and the other vagaries which I've referred to. The protection of human dignity has been bolstered, and the prohibition of torture and all other attacks on physical integrity are guarantees of this. Whilst we will build on what we've achieved so far, the Cameroonian government will also pursue efforts to completely eradicate any attacks on physical integrity, which is a sacred value. Chair, honourable members of the committee, ladies and gentlemen, my delegation and I stand ready to provide you with any additional explanations which you consider necessary. Thank you very much for your kind attention.
Thank you very much for this extensive update with pertinent updates on what has been done. I will now give the floor to Mr. Hani as the first rapporteur.
Thank you, Chairman. I too would like to extend a welcome to the Delegation of Cameroon headed by His Excellency Mr. Nkou. Cameroon is a party to the Convention Against Torture since 1986. The Constitution of Cameroon, which was adopted in 1996, recognizes the importance of international treaties and gives them a prevailing place in the legislation. A new criminal code and code of criminal procedure were adopted, and Cameroon adopted its 5th periodic report a year ago on the 3rd of November 2016 on the list of issues dealt with by our committee in 2015. The committee hails the acceptance of Cameroon to accept the simplified reporting procedure, and we do hope that this makes the work of the various bodies of the state party easier, as well as all of the stakeholders involved, in particular the National Commission on Human Rights and Freedoms, civil society, and the future National Preventive Mechanism. There are 2 rapporteurs for Cameroon this morning, myself and Madame Belmire, but the comments and questions that we're going to make represent all of the committee members. Chairman, may I start out by looking at the voluntary commitments taken by the State Party in its national report, submitted to our committee, as well as the positive aspects that we must welcome. First and foremost, in the report, the State Party takes on the voluntary commitment to combat prolonged or pre-trial detention. This is in paragraph 121. The State Party lists a number of measures taken during annual meetings in the Court of Appeal, as well as directives and circular letters of the Ministry of Justice, the Guardian of the Seals, to reduce and combat the phenomenon of pre-trial detention. There's also an increase in the number of magistrates, going from over 1,000 in 2012 to 1,047 in 2014, as well as the increase in the legal staff, legal personnel. Other commitments have been taken also, and Ambassador, Your Excellency, may I remind you of paragraph 187 and 88 of your report, whereby during the period between the 4th and 5th reports, the authorities in Cameroon have been committed to implementing all of the previous recommendations following the consideration of your last report before our committee. You have listed 3 points. First of all, you mentioned the issue of prevention, with the opening of discussions on the creation of a national mechanism for the prevention of torture. The second point you mention is the punishment of perpetrators of acts of torture. And the third point, the financial compensation granted to victims. These are the 3 themes that you have opted to address in our previous concluding observations following the consideration of your 4th periodic report. In paragraph 188, you mention a number of challenges to be faced and the importance of building on what you've already achieved. You talk about the need to protect witnesses, as well as the need to provide support and care to victims, and also the need to improve conditions of detention by reducing prison overcrowding, by addressing prison food, as well as improving prison infrastructure. You yourself, Your Excellency, mentioned the positive steps taken, in particular the ratification of a number of international and regional treaties, as well as the adoption of new laws, particularly the new criminal code and the new law to combat trafficking and smuggling in persons. You also mentioned the establishment of a number of programs and policies, particularly the National Action Plan to promote and protect human rights. Before I begin with my list of issues, I would like to focus on one point which I feel to be important, very important indeed for the committee. That is the ratification of the optional protocol to our convention. Your country signed the optional protocol, but we are still awaiting ratification. In your report, you mention a number of reflections and discussions, particularly in paragraph 110 of your report. You say that the ratification process is completed domestically with the adoption of a decree number 2010/347 of 2010, and that we still have to await the depositing stage, depositing the convention with the UN Secretary General. Since the 19th of November 2010, almost 7 years have elapsed, and your government hasn't deposited the ratification instrument. However, your national ratification process is completed, according to what you say. So that is my first question. In other words, when do you believe that you can complete that process by depositing the ratification instrument? Moving on now to Articles 1 and 4 of our convention. Your national legislation, in quite an appropriate fashion, has incorporated the definition of torture. That is the definition set out in the convention. And I believe that the legislation there is quite positive. However, we do note that in spite of the law criminalizing torture and in spite of the heavy penalties enshrined in the law, most of the sanctions handed down are administrative in nature. And we note that your country hasn't used criminal sanctions or punishment to punish the crime of torture. In some decisions taken by the justice system, there have been suspended sentences handed down. So the law, there's a gap, if you will, in the law criminalizing torture, which is considered as a serious crime, and practice. There's a gap between law and practice, where we see quite lenient sentences meted out. They are not commensurate with the seriousness of the acts committed. A second point now, when it comes to the definition of torture, as is set out in Article 1 of our convention, there is an exception with legitimate sanctions, and that's the text of the convention itself which mentions that point. However, as you are aware, our committee has jurisprudence, and we believe that these legitimate sanctions must be included in international law. They need to be recognized internationally and not just falling under national legislation. And that is why I'd like to ask the first question of you. What are the legitimate sanctions that you exclude from the scope of the application of the definition of torture? Moving on now to Article 2, primarily fundamental legal safeguards to detention. In our concluding observations previously, our committee noted that Cameroon had a special division for the monitoring of the police force within the Ministry of National Security. Nonetheless, our committee voiced its concern not only to you but also to other states concerned as to the independence of that body. And we also expressed concerns about the very low number of complaints that had been followed up on by that body. we recommended that you set up an independent body tasked with investigating allegations of torture in an independent fashion. In your report, you haven't mentioned the establishment of or the implementation of that recommendation. Could you clarify that point, please? What measures have been taken by your government to guarantee the independence of the investigative body tasked with investigating human rights violations, in particular torture committed by the police force? Could you give us an idea about the number of complaints that have been lodged, as well as the results of the investigative inquiries? Moving on now to the guarantee of having access to a lawyer and of notifying a family member. There again, you have legislation which seems to be quite correct and appropriate. However, in practice, information we have from credible sources point to hindrances in that regard. What are the reasons for a lack of a lawyer, in particular during the first early hours of the procedure? Is it because there aren't enough lawyers, or is it because of a lack of information of those deprived of their liberty? What are the causes leading to a lack of harmonization between laws guaranteeing access to this basic right and the actual reality whereby this right is limited? Another point of concern to the committee is as follows. Having access to secret detention centres, or the use of secret detention centres. We have a lot of information from credible sources, from civil society, in particular Amnesty International. They all talk about secret detention centres as part of combating terrorism. And there, I would like to say that the anti-terrorist struggle is a legitimate one. Like other states, you're entitled to protect the right to security and the right to life of all of your citizens. The right to life and to safety and security are part and parcel of the universality of rights. But this legitimate struggle must be waged by using legitimate means. The issue now of being considered or examined by a doctor, this is problematic also, given the very few doctors available. In your report, and you give the figures from the Ministry of Justice, of Human Rights and Justice, you say that 23 doctors are employed in 87 prisons in the country. This means that there is one doctor for every 4 prisons. And you've few nurses also. So there's a clear lack in medical staff. But we can also add to that the issue of the independence of the doctor. As you know, that safeguard is the right to be examined by an independent doctor, independent from the authority holding that person. So what measures do you intend to take to implement that fundamental safeguard? Another point which is mentioned in your report is as follows. The person is entitled to be examined by a doctor, but the person has to pay for this himself. What happens to those who are in need? Isn't there like a 2-track system here? One for those who are wealthy and one for those who are poor. I'd like to come back to the issue of your Code of Criminal Procedure, particularly the transfer of an inmate to a hospital. There again, the person has to pay for consultation costs. Could you tell us about the resources available to assist inmates who can't afford to pay the medical care and medical consultation? And could you also tell us about the independence of the medical examination? We issued a recommendation in that regard, but apparently the Code of Criminal Procedure has not been amended since 2005. So the committee would repeat its previous recommendation in that regard. Another fundamental safeguard is to do with the right to be informed of the charges brought against the individual deprived of liberty, an individual that is detained. Could you give us an idea as to whether this safeguard is fully respected and upheld in practice, particularly because your report mentions visits by judicial authorities to some prisons or to persons who are accused or convicted, where this right is not yet fully respected? Could you give us some statistics as to respecting that fundamental safeguard? As part of the anti-terrorism fight, I would add to that roundups, etc., whereby the police and the army search and arrest persons without a warrant and without explaining the reasons for their arrest. What measures have you taken, do you intend to take, in order to eliminate the abuse and arbitrary arrests that occur? And I'd like to know about the possibilities of an appeal for those who are arrested without a warrant, particularly as part of the combat against terrorism. Your Excellency, you yourself mentioned that as part of the proceedings against the alleged perpetrators of terrorism, those proceedings take place by respecting the principles of a fair trial, but don't always lead to systematic convictions. Could you give us some figures there again about the number of persons who've been arrested during those operations who aren't systematically convicted subsequently? Doesn't that also constitute abuse there? Now, the right to be brought before a judge in a minimum time frame. During the fourth consideration of your fourth report, we said that that law hasn't been respected and that the time lanes of custody of 48 hours haven't been upheld, including the possibility of prolonged renewable detention upon the authorization of a prosecutor. Now, the reasons behind this apparently are the fact that the registers and cases aren't kept properly. Have any improvements been made since the fourth periodic report? And as regards the strict regulatory status of custody. There is another question which ties in with the fundamental safeguards, and that is corruption. Some information we have available points to corruption where people pay bribes so as not to remain in lengthy pre-trial detention. Your Code of Criminal Procedure requires the respect of laws governing criminal procedures. You also require that law enforcement personnel that violate the maximum period of detention can be held accountable for that. Could you give us some figures, some statistics? Could you tell us about cases of those tasked with enforcing the law who have been sanctioned and convicted for not upholding the legal provisions governing pre-trial detention? In your report, you mentioned a visit to the Yaoundé main prison 1.5 months ago, where the judicial bodies discovered that persons are held there even after serving their sentence. this is a specific operation which has been successful. You mentioned that 120 persons were released following that visit, that check-up visit. But I'd like to know whether you have systematized monitoring of visits, or are these visits that occur after a certain period of time? Does it mean that persons are kept in prisons even though they have served their sentence? Now, under the heading of fundamental legal safeguards, I'd like to come back to combating terrorism, as well as fighting against the terrorist group Boko Haram, which is responsible for a significant number of atrocities and attacks committed against civilians. And I'd like to come back once again to the Amnesty International report, which mentioned the systematic use of torture in the context of combating terrorism, using secret detention places, particularly in Salak and Olak, in Yaoundé, and the use of torture chambers as well as torture techniques. If we tie this in with what you said in your introductory statement earlier, that a lot of arrests don't lead to convictions. Persons are arrested, they undergo torture, and the torture is not efficient or effective. And then at the same time, you're creating victims. So what measures have you taken to investigate the allegations of these presence of secret detention centres? These are allegations that have been made public by Amnesty International. And we do have some information which state that there are mass graves. We have information that in the Maroua Centre, you mentioned the prisons, but other information would say that this is a secret detention centre in Maroua, where a number of persons were placed following a roundup, and 25 persons passed away as a result. Have any inquiries been launched into these complaints? Have they been brought to the attention of the public and to your government? Still on fundamental legal safeguards, I'd like to ask about legal aid. In the report, you mentioned that the Ministry of Justice in 2015 received 225 requests for legal aid, and only 69 requests have been partially granted. In other words, this is an acceptance rate of less than 2/3, and the remaining requests were rejected. So my question there is, how do you explain this very low rate? First of all, the rate of legal aid, requests for legal aid, as well as the number of cases granted. So what measures do you intend to adopt to ensure that all those in need have access to the law and to legal aid? We have a lot of information about the number of lawyers that are insufficient. And I wonder whether the government could think about this point and could perhaps open up to other forms of expertise and legal aid and advice by involving, for example, specialized NGOs in order to provide legal advice and aid and to fill the gap in the shortfall of lawyers. Following the fourth periodic report, we made a recommendation on the habeas corpus. Could you provide us with figures about the appeals lodged to question the legality of detention? Is this something that is available and accessible nationwide? As to the other legal safeguards, with regard to detention and the partiality of judges. My colleague, Madame Belmire, who is a judge, will focus on those issues. With respect to female genital mutilation, I note that headway has been made, and you've mentioned this point. My colleagues, Ms. Gaye and Ms. Raku, will come back to that issue. May I now move on to Article 3, the principle of non-refoulement. Of course, there are some positive aspects, the adoption of the law, the establishment of the ad hoc ministerial commission. All of that is very positive indeed. But could you tell us about the statistics as to the number of asylum applications that have been recorded, as well as the number of applications that have been granted, the number rejected, as well as the number of persons returned? I'm asking this question because credible sources tell us about a high number of refugee status applications that have been granted, and this is something quite positive. However, at the same time, there are approximately 100,000 Nigerians, including children, whose asylum applications have been rejected and have been returned forcibly to the border, violently also, without having had any access to asylum procedures. Could you tell us about those figures and the situation of these Nigerians who have been forcibly sent back, who didn't have access to the fundamental rights of all of those who seek asylum? When it comes to the management of the asylum procedure, there's substantiated information that there's ill treatment, acts of sexual acts against asylum seekers, particularly in the far north of the country. And these are acts committed by the military. Once again, we received information about those allegations, so I'm telling you about them to receive comments on them. Now, when it comes to combating Boko Haram, do you draw a distinction between the terrorist combatants, the soldiers, and the civilian population who are fleeing these crisis and conflict? Other information tell us about precarious living conditions in refugee camps in Minao. I'm not sure whether I've pronounced that correctly, my apologies. Minao. As a result of overcrowding and a lack of basic services, particularly access to water, food and healthcare. Turning now to Articles 5 and 5 to 9 of our Convention, could you provide us with cases whereby universal jurisdiction has been invoked? Are there complaints against those committing torture from other countries, and against whom there are inquiries that have been launched? You replied to a question about extradition treaties. Since the signing of that treaty, do you have any statistics to give us as to the number of persons who have been extradited from or to the countries with which you have extradition treaties, as well as the reasons for their extradition? Mr. Chairman, I'd like to come back to three key problems. I mentioned the fight against Boko Haram, and I'd like to come back to the social crisis that you mentioned, Ambassador. In all countries there are social crises, there are democratic, independent claims. However, I was struck by the fact that in your speech, you yourself acknowledged that persons arrested are subject to proceedings before the Yaoundé military courts. This means that we have a military court that is trying civilians as a result of a social movement. And these are not military individuals. The military courts are there to try military personnel. The media have called this the Anglophone English-speaking crisis. This encompasses violations that have been documented by civil society organisations, and you yourself acknowledge that those arrested have been brought before the military courts in Yaoundé.
Obviously, our committee constantly recommends that military courts be used only for members of the armed forces and not for civilians. So I'd like to know what measures you plan to take in order to respect this principle of only trying civilians in civil or ordinary courts. You have taken certain measures to restore peace, the release of certain individuals, but this also raises the problem of interference of executive branch in judicial matters. You mentioned the fact that it was the head of state that ordered certain cases to be dropped. Clearly, it's an attempt to restore peace, but it does raise the problem of the separation of powers. So I wonder if you would be so kind as to comment on the measures that you plan to take to ensure a clear separation of powers. Ms. Belmire will focus in greater detail on this matter. I would also like to refer to certain excesses in your counter-terrorism operations. There are certain convictions for acts which are not normally linked to terrorism. There are certain journalists who have been convicted of attacks on national security, some of them having been subjected to torture and ill treatment during their detention. One such example is the journalist Ahmed Abba. There are other acts of intimidation which have been perpetrated against journalists and human rights defenders. They have been targeted when revealing cases involving the authorities. One such case is that of Maximilien Ngombe. A number of civil society sources have referred to the fact that the Counter-Terrorism Act is implemented in an abusive fashion against journalists, and that proceedings are tarnished by irregularities. I'd like to know, what measures do you intend to take in order to prevent the Counter-Terrorism Act being abused in order to intimidate journalists and human rights defenders? I would also now like to refer to the independence of the National Human Rights Commission. It plays an important role in Cameroon, as do all institutions in Africa, as part of the coordinating mechanism of national human rights institutions. Your national body had an A status, so its independence was recognised by the Credentials Committee in 2010, but it does seem as though the situation is changing. It's not going in the right direction. So I'd like to ask you 3 questions about the National Commission on Human Rights and Freedoms in Cameroon. The first question: what safeguards are provided for the independence of the Commission, in particular when it comes to the appointments procedure, so that you can ensure that members of the Commission are independent and separate from the ruling political party, from executive branch? Secondly, I'd like to ask about resources for the Commission. I'd like to know what the government's guidelines are in order to ensure that the institution has the necessary resources to complete its mission. And thirdly, I'd like to ask about any obstacles to the activities of the National Human Rights Commission. it has been prevented from visiting certain detention facilities according to credible information that we have. For example, the Commission tried to visit supposed secret detention facilities, but has not yet had the opportunity to do so. There are names, places and details of such facilities that have been provided to us in civil society's reports. So, Chair, Excellencies, those are the questions that I wanted to ask and the allegations which I wish to refer to you so that you will be able to comment on them. Thank you.
Thank you very much, Mr. Hani. We now move to Madame Belmire, the second rapporteur on Cameroon.
Merci, Monsieur le Président.
Thank you, Chair. I would like to begin by bidding a cordial welcome to the State Party delegation led by His Excellency, the head of Cameroon's permanent mission in Geneva. I pay tribute to all the work which has been carried out by the State Party in drafting its report, which is its answers to the list of issues drawn up by the committee. Well, truth be said, Cameroon is from the same continent as my own and Mr. Hani's country, with the same potential characteristics and problems. Cameroon is an important country in Africa in many domains. These domains encompass all walks of life, and there are many such states in Africa that play such a role. I would like to base my comments on a number of matters which have been raised in the opening statement by the head of the delegation. Thus, I would like to raise a number of issues concerning the specific way in which the Convention Against Torture is implemented in your country. I would like to begin my round of questions with one which could be asked of many countries in Africa and indeed other continents. I'd like to ask about the relationship between the judicial and executive branches. One could say that it's not particularly clear-cut, given the fact that the rule of law is not always very well anchored. One could say that to a certain extent the judicial branch must answer to the executive branch. For example, it is the head of state who appoints and dismisses members of the judiciary. So, the reasons for such decisions being taken may not always be transparent. So I wonder if you could shed some light on this notion. Is it a mere allegation, or are there other bodies which make proposals for the appointment or dismissal of judges? At certain stages of the proceedings, then, that would enable the independence of the judiciary to be safeguarded, or does the judiciary really have to answer to the executive branch? I would also now like to refer to information that we have received concerning a certain control of the judiciary. For example, we've heard that Paul Aya-Abin, the Attorney General of the Supreme Court, was detained on the 21st of January 2017. He was placed in secret detention but was released on the 30th of May of this year. According to the information that we have received, this was because of a violation of Article 629 of the State Party's Criminal Code. There are other cases, but we would like to hear your explanation of this case. I would like to know if there is some higher council of the judiciary which takes a decision. We'd like to know exactly what proceedings led to the arrest and detention of this leading figure of the Supreme Court. There are perhaps national reasons for doing so, but one mustn't forget that the rule of law should prevail. Now, I've got some other questions concerning the justice system and the judicial branch. Apparently, there is a certain rivalry between the Ministries of Justice and of the Interior. It seems as though the justice system is divided into different sections. So, the criminal justice system comes under the auspices of the Ministry of Justice, but law enforcement agencies fall under the aegis of the Ministry of the Interior. So, we can say that procedural law is regulated by the Ministry of Justice, but that all other areas of the justice system do not fall completely under the purview of the Ministry of Justice. Now, according to certain international bodies, including treaty bodies, have called for state parties to transfer temporary detention facilities to the control of the Ministry of Justice. I believe your state party has considered this, but has delayed this procedure. So I wonder if it's because of the current security climate that has delayed these proceedings. I don't know if it is because of your counter-terrorism operations that this situation has arisen. I don't know if it's because of the influx of refugees. I don't really know why there is this division between two ministries that have different aims. Now, I'd like to refer to military courts. Ambassador, head of delegation, you referred to the fact that there is an act from the 12th of July of this year which establishes a military justice code providing military courts with jurisdiction for punishing serious crimes such as war crimes, crimes against humanity and genocide. So, special justice system has been established under this military justice code for crimes which are a violation of human beings' physical integrity. So there are certain international instruments, such as the Convention Against Torture, which recommend that military justice be circumscribed to offences committed by members of the armed forces or which fall fully within the sphere of military activities. So, I wonder if you could give us a better explanation as to why you have chosen this structure for trying such crimes. I would like to know as well if we can consider that there is consistency between or among judges, military judges, prosecutors and police forces that manage detention facilities, the General Directorate of National Security and any other law enforcement officers. Who does what exactly? I'm sure that you can answer this question, but I think that the heart of the matter is being able to understand how these different bodies interact with each other and how they coordinate amongst themselves. So we'd like to know how things work when it comes to interrogation. Mr. Haney referred to the definition of torture, and we can say that it is largely in line with the first article of the Convention. We find the notion contained in Article 1 concerning lawful punishment. I'd like to know what is considered to be lawful punishment in your country. How does it relate to life and physical integrity? It is a notion which is contained in the Convention and in many different national legislations of state parties to the Convention. So I would like to know to what extent this notion of lawful punishment is incorporated into your criminal code and other legal instruments for your criminal justice policy. According to your report, and now I'm moving on to fundamental legal safeguards, in paragraph 14, that the staff of national security are responsible for the health, life and physical integrity of those people who are in custody, and that they, under no circumstance shall they be subject to torture, physical or mental abuse, and so on and so forth. So I would like to know, with a view to the implementation of Article 11, how you ensure that torture and degrading treatment or punishment is prevented. You refer to police facilities being monitored because you have the police's police. So it is the monitoring body which monitors itself, because the police officers belong to the same force. So it is the same force which monitors those who are responsible for the conditions in which people are held. Mr. Haney referred to the period of police custody, and that police custody can be prolonged, often with a view to obtaining a bribe from the detainee or his or her family members. When it comes to examination by a physician, it states in paragraph 13 of the report that it may be countersigned by the doctor chosen by the detainee, and that medical examination may be carried out by a physician of the detainee's own choosing at his or her own expense. So you have many people who do not have enough economic resources. So let's imagine that we have a detainee who must be examined by a physician, but at his or her own expense. We mustn't forget that legal aid does not cover all stages in proceedings. Legal aid is only available for the trial. This means to say that access to a lawyer and a physician is not guaranteed for those who do not have their own economic resources. Thus, I would say that there is a severe problem in accessing legal aid. This is because very often detainees are vulnerable as a result of their scant economic resources, of belonging to a minority or being a refugee, or because they're someone who lives with a disability or something of that ilk. I'd now like to move on, if I may, to the issue pertaining to the prevention and eradication of torture. Head of Delegation, you have claimed that your justice system is tackling this issue and that rulings have been handed down by the courts, and it's true to say that there are a number of cases which have been referred to the courts, cases of torture, inhuman treatment, wrongful police custody, arbitrary detention. So I'd like to hear your comments on this, because the decisions are really administrative decisions or disciplinary measures. They could be warnings. So let's imagine that we have a case of torture or ill treatment which has led to the death of a detainee. That case then leads to a warning being issued, a warning because a death has occurred. Then, when it comes to the disciplinary proceeding, the officer is suspended. Then we have judicial proceedings, but they are ongoing, so we'll have to wait. And when we get a suspended sentence, there are very few cases which lead to effective prison terms being served or fines being imposed. Most of the decisions just result in disciplinary proceedings or warnings or suspension from duty. And if there is a judicial ruling, it's normally just a suspended sentence. So it seems as though enough has already been done to punish these acts. So I'd like to know what is being done to handle these cases. There have been reports, there have been observations from treaty bodies, all going in the same direction. Why is this so? Perhaps one could say that there is information which is missing or was never present. Perhaps through training, such forces can become more independent from this, so that we would have more training for police officers, for members of the armed forces. There seem to be a whole plethora of activities which would play an important role, such as basic continuous training workshops for members of the police force and the gendarmerie. Then there is general human rights training. There is training international humanitarian law. Then the military forces have a handbook for training defence forces in international humanitarian law. There is also a module on human rights and fundamental freedoms for the police force. So there is a certain effort to provide training to law enforcement officials, including in particular members of the judiciary. There is training in identifying and detecting torture. There is multidisciplinary training, if we can use that term. There's also cooperation between your national government and the African Union's Human Rights Commission. There's training for diplomats, for doctors, and there are seminars and training workshops, so we can see that efforts are being made, but we cannot see any evaluation of these training courses. We don't know what the impact of these training courses has been. After all, these are the people who are supposed to implement our convention. So we need to hear about your evaluation of these courses. You say in the introduction to report that training is bearing fruit, but that's not detailed enough. The allegations of torture and ill treatment are truly high in number, so we'd like to hear your comments and explanations. Are they baseless allegations, or is there truth in them? We need that information so that we can nuance the information we have and make sure the information we have is up to date. We've also got this problem of the efforts to reduce torture and ill treatment. Interrogation methods are an issue here, as well as the monitoring of places of detention. Before we move on to prison overcrowding and everything pertaining thereto, I'd like to refer to the fact, first of all, that you have signed the optional protocol to our convention, so I'd like to know what's the state of play concerning the establishment of the National Preventive Mechanism of Torture, which would have a mandate to monitor detention facilities.
There are legal detention facilities, and I believe there are 26 of these. So I would like to have the exact figure of places of detention or detention facilities. There are detention facilities in regions that experience political unrest, in particular in the north and south-west of the country. There's a problem of migration and migration flows. These are migrants that are fleeing areas of conflict, where they are abused and ill-treated by Boko Haram. So this type of monitoring needs to be better governed. It needs to be orderly, and this is the work to be done by the NPM. We're well aware that the National Commission on Human Rights and Freedoms is undertaking major efforts. And it holds accreditation status A and not B, so developments have occurred in its work. It says that it is relatively independent in conducting its work, but it has very few resources available to it. There's a problem when it comes to conducting visits, because a number of NGOs do not have access to detention facilities. As I said earlier, very often these detention facilities are run by the police force. And there are allegations of abuse and ill treatment. We have information about a number of torture methods that are used. Now, when it comes to access to justice, to the person being brought before a judge, all of this takes quite a long time. This means that a person is being kept for a prolonged period of time, and they're asked for money, even though they may not have any economic resources.
Bon, les choses se...
Well, things become even more complicated with the Counter-Terrorism Act. We could say, well, we could ask about the definition of terrorism here, and it can be said that nowhere can we find an exact, accurate definition of terrorism. You won't find a definition in the international human rights instruments as well as in legislation of other countries. However, this is a concept that's being worked and built upon. Definitions of terrorism are maturing, and they are subject to a very broad interpretation, leading to a large number of acts. So this means that anyone who is supposed to be related to terrorism may in fact be arrested. We find that these arrests take place in an almost systematic fashion. Arrests of persons from all backgrounds, men, women, various age brackets, persons who are vulnerable. And a large number of these individuals are, in fact, minors. In the introductory statement, it was said that young persons are used as explosive bombs or used to undertake various types of actions. Minors are treated as adult detainees, and they undergo abuse and ill treatment. And there is a problem of overcrowding. This contributes to their situation. There's a problem of overcrowding in detention centres, which have a hosting capacity of 17,000 persons, but in actual fact, they're holding over 28,000 persons. There are other facilities that are deemed to be illegal, particularly in the conflict regions that suffer from Boko Haram attacks. So these regions have been identified, persons have been arrested simply because they provided food to Boko Haram, to the terrorist group. There are villages that have been completely destroyed, houses have been burnt, and here I'm referring to the activities undertaken by the military. It's as if we're dealing with an emergency type situation. Those who flee their villages can be arrested and imprisoned and tried because they have some type of relationship with terrorism. So all of these are issues that need to be clarified, particularly from the standpoint of protection. The protection of those who are deprived of their liberty, they're victims of abuse and ill treatment. You need to look at their rights of having access to justice, appeals that they can lodge with their lawyer. They need to have easy access to the justice system. There is a whole set of factors here involving the Ministry of Justice, as well as the fact that the judges depend on the executive. Just to give you an example, we have the case of a former Secretary General of the President's Office of the Republic. This is someone who was imprisoned and who had a whole raft of lawyers available to him, but basically he gave up, he threw in the towel because there was no point in defending this individual. There was a request for a fair trial. So replies do need to be given about our concern to protect victims of torture. Witnesses also need to be protected. The state party says that for the time being, legislation does not fully cover the protection of witnesses. Turning now to measures, follow-up measures, that is, in your report, you say that follow-up management measures have been taken, follow-up on certain situations, and that the legal and prison systems have been improved. You say that consultation has taken place between the legal authorities and others. So we would like to have more information about the cases of follow-up on inmates from the military system. And we'd also like to hear about the arrest of the director of the prison. And we'd like to hear about the effective implementation of legal measures. You've talked about directives and circular letters. And we would like to know about the impact these actions have had on the smooth running of the judicial system in Cameroon. I would now like to turn to compensation as well as inquiries and complaints. We note that there is indeed a problem when it comes to lodging complaints for victims of torture. Some people have filed complaints and they have been provided with responses, but very often victims do not file a complaint because they fear reprisals. And as a result, a large number of individuals do not file complaints. In the State Party report, efforts have been made in order to tackle this issue. Often inquiries aren't completed and they do not lead to charges being brought or the arrest of persons. In the State Party report, a number of cases are cited. I believe it's paragraph 19, which talks about 14 cases of persons who have been arrested and released. These individuals were arrested illegally, wrongfully. There are cases where the reports have been cancelled or nullified. But what happens then when persons are released and have been arrested wrongfully or abusively, if you will? So what happens to these people who are ill-treated? This is a case I believe that you cite in your State Party report. There are 14 cases listed, and you have another set of cases as to the sanctions, the punishment meted out. But as I said earlier, some of the punishment is very lenient indeed and is not in line with the seriousness of the acts committed. As to compensation now, or reparation, you say that financial compensation measures are included in the conviction, and you do mention this point in the report. But in addition to that, there is a contribution made from civil society organizations, from the Représentant, the Cameroon Center, which has set up a comprehensive program with multidisciplinary procedures involved. You also mentioned that there's a contribution from doctors, psychiatrists, and other professionals. A compensation committee has been established, and I would like to know whether the actions undertaken by this committee actually are. I'd like to know about the statistics and the number of persons, if you have any available, the number of persons who have been compensated, that is. And I'd like to know whether that compensation covers the content of Article 14 of the Convention Against Torture. Now, turning now to Article 15. In the reports we've received from NGOs, we note that particularly military judges do not attach full importance to allegations of torture, whether these be lodged by the victims themselves or by their lawyers. So here there is a problem when accepting confessions that have been extracted under torture. There are a large number of reports that who really insist that you admit that acts of torture have been committed by the government. In paragraph 160 of the report, it is said that the research and investigations undertaken have not made it possible to nullify or cancel evidence or testimony obtained through torture or ill treatment. And you refer to the Article 315 of the Code of Criminal Procedure. We would like to receive a lot more information about that point. I'll move on now. And this is something which was dealt with by Mr. Haney. But I'll move on to human rights defenders, trade unionists, and journalists. There's an example here of alleged acts involving persons, or a person who was the executive director of a human rights organization in Central Africa, who is called Maximilien Nogombe. It is alleged that harassment took place, and we would like to have further information and clarification there. But I am asking that question again because we have a lot of reports about this issue, and any clarification you can make to that issue would be most welcome. Because this really was, this is an exemplary case which is at the forefront of someone who defends human rights. And given her title and her role, this is something very important indeed. And it involves the Central African Republic. Now, there are other questions I would have liked to ask. I will leave it there, however. But I would like to say that with us in the Federation of African Jurists, we were working with very competent women from Cameroon who defended human rights as well as the rights of women. And these women told us about developments and changes that have taken place in the situation of women. I would like to know, quite apart from the issues of FGM, early marriage and stigmatization of women and widowhood, I really would like to know to what extent women play a role, both in the judiciary, at the bar, as well as in other spheres, because these women are very competent indeed and are proud to belong to the State Party. I thank you.
Thank you, Madame Belmire. I would like to ask who of the committee members would like to take the floor. have Mr. Toussé, Mr. Rako, Mr. Chiang, Mr. Bruni, Ms. Geyer, and myself. This gives up to 10 minutes to each speaker. Mr. Toussé, you have the floor.
Merci, Monsieur le Président.
Thank you, Chairman. First and foremost, Ambassador, may I extend a warm welcome to you here in Geneva to the committee. We were quite afraid and we were quite pleased to see a delegation with us today. I have 4 sets of questions on very different subjects. The first set has to do with the Anglophone crisis. In your statement, you've mentioned that, and I would like to receive some information. This is something that was raised also by Mr. Hani, but we still have some outstanding questions. First of all, it would appear that information sent to us would lead us to believe that the security forces in Cameroon have had recourse to excessive use of force during demonstrations that took place between November 2016 and February 2017 in the north and southwest of Cameroon. We've received a lot of consistent information which have said that persons have been severely beaten. At least 7 persons were shot dead. Many demonstrators were arrested on the grounds related to terrorism, and there were 24 persons who have disappeared. Several arrests took place, and the President of the Republic ordered the release of some demonstrators. But there are several questions that arise here. First of all, how many demonstrators are still held in detention? Have inquiries been opened, and have procedures also been opened in order to shed light on the excessive use of force during the repression? The second set of questions pertains to some acts taken in the fight against Boko Haram. The starting point here is the report of the High Commissioner for Human Rights, which was submitted to the Human Rights Council on the 9th of December 2015, in which it reports about serious human rights attacks and violations committed against Boko Haram, but also a number of acts committed by military and security forces of Cameroon. As regards the report in paragraph 78, a request was submitted by the OHCHR which focuses on the need to open inquiries when proven acts of torture, ill treatment, abduction may have taken place during the fight against terrorism. So here I would like to have some replies which would enable us to assess the measures that have been effectively adopted by the state following the submission of that report. In that same report in paragraph 58, and I quote, it states that in Cameroon, witnesses questioned by the OHCHR have said that the defense forces killed persons during raids that they launched following Boko Haram attacks or on the basis of complaints of self-defense groups. According to the information provided by witnesses to the OHCHR, the Cameroonian army has killed over 17 persons during the raids, and most of these deaths took place in the Bilia, Dobla and Magdem villages. Corpses were thrown into mass graves and into fields during an operation. So on the basis of that report, or following that report, I would like to know whether investigations took place, whether exhumations of the bodies took place in the zones mentioned. As part of the information sent to the committee, we learnt that approximately 260 persons were arrested on the 26th of January 2014 in Magdem Double by the Cameroonian forces, and 192 of them disappeared. There will be at least 25 persons who died that evening in detention in Maroua, according to official communique. Here we would like to have answers and explanations as to possible inquiries as well as autopsies that took place. Lastly, Amnesty International documents a number of facts. 7 persons allegedly were killed by the BIR during an operation in Bornery in November 2014. and apparently the death of 30 persons took place because of acts of the army in Agashi in 2015. And there again, we would like to receive information about possible inquiries and procedures that have been opened. Lastly, based on sources provided by Amnesty International, there are 17 cases of enforced disappearance that were identified between April 2015 and February 2016, without any inquiry being opened by the Cameroonian authorities. Could you please provide us with the information there? I'd now like to come to the third issue that I wanted to raise. That is the amendment of the criminal legislation as regards rape. There is a passage, an article in your report that struck me. You mentioned the repeal of the provision pursuant to which rape is not sanctioned criminally if the victim accepts to marry the rapist. Now, in your reply, you say that the reading underway of the criminal code will enable you to consider that issue. I found that was a little clumsy, if you will. This isn't a question, it's a problem. And here I would like to have specific information about the progress of this legislative situation to put an end to something that removes dignity from women, and it needs to be stamped out in all states who are party to the convention. Lastly, my fourth question, it's quite a general one, and it has to do with places of detention in Cameroon. Now, I know that the response will be based on an economic argument. In other words, in several reports, and this was highlighted by the National Human Rights Institute of your own country, it was said that the prison situation in Cameroon is extremely alarming. Detention conditions are clearly run counter to our convention, and the economic argument, I think, will be put forward. And I think you said this earlier when Mr. Hani took the floor on the issue of the representation of lawyers in prisons. Cameroon is a poor country. Of course, we can accept the economic difficulties faced by a number of states. Nonetheless, when we talk about ill treatment and torture, I find it difficult to see the economic argument as being acceptable. Of course, there are economic arguments and constraints. Nonetheless, there is a need to rethink the problem and possibly to devise strategies and policies that would make people aware of the problem and ensure that conditions can gradually improve over time. And I would like to know the stance of the state party as regards the prison situation. I'd like to know about the resources. Given the economic limits of the country, what measures or resources could be adopted to improve the situation? Thank you, sir, and I will give the floor to the other committee members. Thank you.
Thank you, Mr. Toussaint. Mr. Bruni.
Merci.
Thank you, Chair. I too would like to warmly greet the representatives of Cameroon to this committee. I've got some questions concerning Article 2 of our Convention on Prevention. These are issues which have already been raised by the rapporteurs, but my questions take a slightly different tack. So, my questions will deal with paragraphs 30 to 36 of your report pertaining to the rights of people held in police custody or detention to be brought swiftly before a judge. There is this unjustified abuse of the provision for extending police custody and pretrial detention. That's useful information that we have heard, but in all the cases that you have addressed, you have referred to the release of those wrongfully held, but you do not make any reference to the punishments imposed on the perpetrators of such acts. Could you tell us more about any punishments then imposed on police officers who have wrongfully held people? Could you give us that information with particular regard to the 7 cases mentioned in the report? In paragraph 38 of your report, it states that the law has not yet been amended to take these concerns into account, that is, the accessibility of legal aid for the most disadvantaged. This is an issue already raised by my colleagues, but I've got a different angle. I'd like to know what happens when a person who has no means of defence or of hiring a lawyer is taken to court and has to defend himself against the accusations of the prosecutor. Can we really talk about twin-track justice or two-speed justice? Or are the authorities really doing something to ensure that the most disadvantaged have access to legal aid? I'm going to skip over my question on the optional protocol because it's already been dealt with by other colleagues, in particular Mr. Haney. Nevertheless, I would like to take this opportunity to encourage you to complete the ratification process as swiftly as possible. I'd like to know if you have already foreseen a date for the deposit of your ratification instrument. If you have got a date, please would you tell us? I'd like now to ask you questions on Article 3 of the Convention. The report states that the majority of refugees come from neighbouring countries going through times of turmoil. Notably in conjunction with the activities of the Boko Haram terrorist group and because of counter-terrorism operations. I would like to know if special protection is provided to those fleeing violence, massacres, abduction and violence perpetrated by the Boko Haram terrorist group. Can I now move on to the conditions of detention? My colleagues have already raised this matter in some detail. Notwithstanding, there is one problem which has not yet been addressed in detail, and that is the matter of prison overcrowding. I read in a local press article published in August of last year that stated that in 2014 the government declared that there were 26,702 detainees, whilst the prison capacity was for 17,000 inmates. So we can see that the theoretical capacity of your detention facilities falls well short of the current occupancy levels, so there is a severe problem of overcrowding. We heard that at that time, though, the prisons management system was looking at ways of reducing imprisonment. I'd like to know if any tangible measures have been taken as a follow-up to the study, and have they produced the necessary results? It seems that not to be the case, because in a more recent press article published on the 31st of March of this year, the situation in Maroua prison in the northwest of the country was highlighted. It was built in 1935 for a capacity of 500 inmates, but at that time, at the time of going to press, there were 1,890 detainees held there. If that information is correct, then we can say that prison overcrowding has reached alarming levels. I'd like to know if any effective measures have been taken by the competent authorities to resolve this problem. Furthermore, there have been a number of riots caused by prison overcrowding. So I'll leave it at that, Chair, and I'd like to thank the delegation for its attention.
Thank you, Mr. Bruni. Mr. Rako.
Thank you, Chair. On my turn, I would like to welcome the delegation and to congratulate the delegation for the involvement in this important dialogue with the committee. I have two questions, and my first question is related to, as Mr. Hani mentioned before, it's related to FGM practice. A number of reports indicate that girls under 18 years were reportedly subjected to FGM in some isolated areas of the far north, east and southwest regions of Cameroon. The estimated prevalence of FGM is 1.4% nationwide and around 20% in the most affected communities. Some of the recent reports in the field, especially the UNICEF global databases for 2016, indicates that FGM among girls and women between 15 and 49 was 1% in urban centers and 2% in rural areas. The committee is fully aware of the fact that Cameroon has made relevant efforts in combating this very harmful practice. However, there are a lot of shortcomings, but on a positive note, I would like to mention the 2011 National Actions Plan. According to that plan, Ministry of Social Affairs established local FGM committees in the areas where FGM was most prevalent, and in particular in far north region, which is in the view of some international organization was a very good practice. Excellency, you mentioned in your welcome speech that FGM practice has been criminalized and that a new actions plan has been adopted. We would appreciate very much if you could provide us more details on this specific actions plan and maybe other steps that Cameroon have been taking in order to combat the FGM at the practical level. Maybe you could give us some figures on the criminal investigation or maybe on the number of prosecutions under the new provisions of the criminal code that criminalize FGMs. I know the changes in the law are quite recent. If I'm not mistaken, it was July last year. But anyway, if you have such figures, we would be very grateful. My next question is related to juveniles in detention. We received a lot of reports indicating that children too often have a difficult time accessing the justice system and are not consistently treated with dignity when incarcerated. One of the UNICEF assessment report on Cameroon justice system for children indicates that a large majority of detained children, 84% of the total number of children in prison, are awaiting a trial. On average, a child may spend in pretrial detention for 8 to 12 months. Other shortcomings related to juvenile justice is the lack of educational programs and reintegration, specialized programs for the children, except for the prison in Bamenda. That is the only prison in the country with a school inside and with some workshops and educational programs run by Catholic Church and some of local NGOs. Prison conditions are very harsh, and the main allegations of the children are related to lack of food, lack of running water, and lack of legal assistance. In this respect, and taking into account all these findings provided by the international and human rights NGOs, we would like to be updated on the recent developments in the country regarding juvenile justice, including any potential improvements in the detention conditions for the children, any improvements or any initiatives regarding alternatives to detention and non-custodial measures, and other relevant initiatives that Cameroon has been taking during the reporting period. Thank you very much.
Thank you, Mr. Raku. Mr. Chang.
Thank you, Chair. Let me join my colleagues in warmly welcoming the distinguished delegation from Cameroon, which comes to join us for this constructive dialogue. And I have a couple of questions regarding the refugee status and also the stateless persons in our country. We are aware that for the last few years, Cameroon has been faced with a series of humanitarian emergencies due to conflict and instability in the Central African Republic and Nigeria. These crises have tested Cameroon's long-standing tradition and reputation as a country of asylum. In the East, a first wave of around 100,000 refugees from Central African Republic arrived between 2004 and 2007 and settled in the host villages. The remainder fled the last round of violence beginning in December 2013. Currently, although signs of improvements have been noted in the Central African Republic, the situation continues to be unstable and unconducive to return at the present time. And regarding these the refugees, the concerns are expressed that persons in need of international protection should be given access to the refugee status determination, which is RSD in short, refugee status determination procedure, and are granted refugee status in a fair and efficient manner in order to better fulfill the obligations of Cameroon under Article 2 and 3 of the Convention Against Torture and the Committees of CAS General Comment number 1 and 2, and also in light of the paragraph 28 of the committee's previous concluding observations on Cameroon during the 44th session in 2010. And it is recommended that these can be achieved or implemented by implementing the provision of the Act number 2005/006 of 27 July 2005 concerning the status of refugees, and the corresponding decree 2011/389 by assuming full responsibilities for the RSD. Once again, the refugee status determination. Yeah. Secondly, by allocating the necessary resources and capacities to the refugee management body and its technical secretariat in order to enable it to carry out RSD. And thirdly, by implementing Decree 2016/373 of August 4th, 2016, and the Decree 2007/255 of 4th September 2007, which provides for the issuance of refugee identity cards by the government of Cameroon. It is also concerned that the immediate steps should be taken to combat all forms of violence against refugee and internally displaced persons, especially internally displaced women and girls, including against trafficking in persons, in order to better fulfill the country's obligation under Articles 2, 12, 13, 14, and 16 of the CAT. The committee's general comments number 2 and 3 and paragraph 29 to 30 of the committee's previous concluding resolutions on Cameroon. And these can be, it is recommended that these be implemented by adopting a specific law on sexual and gender-based violence and adapt these anti-trafficking provisions to be consistent to bring them in line with the international standards. Secondly, by strengthening law enforcement and judicial responses in this SGBV, which is a sexual and gender-based violence cases, by increasing resources allocated to the judicial aid and the court system in crisis-affected areas. And thirdly, by ensuring proper training on the SGBV issues to the police and judicial staff and other government actors working in the refugee hosting areas in order to reduce the community's vulnerability to sexual violence and exploitation. And regarding the stateless persons, it is the concerns are expressed that these people, the stateless persons and the persons at risk of statelessness, should be given equal access to their fundamental human rights without discrimination and access to fair and efficient procedures for naturalization in order to better fulfill the country's obligation under Article 2 and 16 of the CAT and the committee's general comment number 2 by inter alia, first, acceding to the 1954 Convention relating to the status of stateless persons and the 1961 Convention on the reduction of statelessness. And secondly, by conducting further sensitization and providing greater resources to civil registries to facilitate free birth registration and the issuance of birth certificates in order to minimize the risk of statelessness. And thirdly, by ensuring that recognized refugees born outside Cameroon can also be issued with substitute birth certificates. And fourthly, and by adopting streamlined regularization procedures for Nigerians and other foreigners to obtain identity and residence documents in the Bakassi Peninsula. With that, I thank you.
Thank you, Mr. Chiang. Ms. Geyer.
Thank you very much, and appreciate the opportunity to probe a little bit into this report. It's the 5th report of Cameroon, and yet we have a series of very serious issues that we're still struggling with. I was very pleased to hear some of the legislative changes that were made and that were described, and I was prepared to compliment you on responding to end the exculpatory provisions that allow a perpetrator of rape to escape punishment if he forces the victim to marry him. It sounded like from your responses in the report and from statements by some of the NGOs that have provided information to us that you've addressed that issue in the legal reforms, but Mr. Touzé has raised some important questions, and I certainly would be interested in the response of how you are ensuring that the perpetrators of rape are being appropriately investigated, prosecuted, and punished. One of the pieces of information we have available to us is the annual report of the United States State Department on human rights. And they said that in 2016, it was their view that there are very few cases of rape that are in fact investigated. So I would appreciate your comment on that. They also indicate that based on studies of your Ministry of Social Affairs and Women's Empowerment, that 52% of women complain that they have been subjected to domestic violence, and half of those say that's happened by the age of 15. I'd appreciate if you could comment on that. But even more concerning to me was the statistic that they cite from your own government report that rape as a result of incest takes place in 18% of all raped women. That's a very high percentage, and I'd appreciate, first of all, if you could confirm that that's what your report, the Ministry of Social Affairs, the Ministry of Women's Empowerment said, and secondly, that the measures that are being taken to address that. Do you have any cases of individuals who have been imprisoned as a result of investigations and prosecutions for rape as incest? I'd be very interested in learning about that. Now, in our questions and our last set of conclusions in the fourth report, we raised a lot of questions about the separation of minors from adults, pretrial detainees from convicted detainees, men from women, and adults from children. And you do respond to this in the report in paragraphs 135 to 137. Yet it still raises questions as to the prevalence of these practices. In particular, I wanted to ask you, because I didn't see any reference in those paragraphs, to the issue of guards. Are female prisoners guarded by male staff? Does that continue? Or are female prisoners guarded only by women, or is it mixed? Can you clarify for us if there is in fact now separation, which is what your report tells us? Appreciate if you could clarify that for us as well. Now, I wanted to address some of the violence against women and gender-based violence questions. We did ask you about whether marital rape is prohibited in your country. In other words, rape is rape. Rape is violence. Rape is not an attack on dignity. It's an attack on the physical integrity of another person. And in that context, this committee and many countries around the world have criminalized rape within marriage, and wondered if you can update us on whether that's the case in your country, what the status of that is. I understand in your report you tell us that assault is criminalized, well, rape is assault, but it's a particular kind of assault. And so if you could tell us if you have any cases where rape within marriage has been criminalized and prosecuted, I'd appreciate that as well. Now, I understand that there is not an offense for domestic abuse, domestic violence in the new penal code. Can you tell us why? Is that something that's in progress? Can you also provide us with some further data? In paragraphs 76 to 78, you present us some statistics. I gather those are summary statistics for all 5 years that the report covers from 2010 to 2014. Is that correct? And do you have any further data since 2014 in that regard? Specifically, I'm interested in the number of investigations and prosecutions of perpetrators of gender-based violence. Now, in paragraphs 76 and 77, you tell us about investigations and convictions, but there's no information on the length of sentences. Can you give us a little information, further information on that as to the length of the sentences and the number of people who are currently serving those sentences? Now, I also wanted to address paragraph 70 of your report. In it, you mention that preventive measures have been taken to curb the prevalence of domestic and gender-based violence through awareness raising and education campaigns. And you later talk about legal support and the construction of shelters. Can you provide us with some information as to the results this has had? Do you have any measurements? Do you have any studies, maybe by private groups, maybe by the government, about the results of these preventive measures? In particular, can you also tell us if the state party is providing funding for legal aid for victims of gender-based violence? And if you're providing legal aid to people in rural areas as well as in urban areas in that regard. Also, when you spoke about shelters, you mentioned there are 8 in the country. Are there plans to increase this number throughout the country, again, especially in rural areas? And if you are, can you tell us the time frame that you have in mind? Now, I was also asked to raise the issue of trafficking, and there are a variety of forms of trafficking in persons that have been addressed in the context of your country's practices. Now, we thought that the legislation in Section 342-1, criminalizing trafficking in persons in the new penal code, is a positive measure indeed. But we are concerned about reports that the legislation is not being enforced. In particular, we understand we've received information suggesting that the cases of trafficking are not investigated, and that instead you rely on NGOs, on non-governmental organizations, to settle cases out of court. This has raised concerns that these are not being treated as crimes and abuse against persons that fall into the category of ill treatment or torture, but rather that they are being treated as somehow administrative matters. So I'd appreciate if you could clarify the procedures the state party uses to investigate cases of trafficking, and how if you're going to work with NGOs, how you can work with them in order to investigate the crimes more fully in that regard. Now, I'm concerned about the issue of trafficking because, again, I read a lot of things, and I read the U.S. government's Trafficking in Persons report for 2016, where they indicate that they are concerned about the fact that and they state that in your country there have been fewer trafficking investigations and convictions last year than the prior year, that there isn't enough resources going to anti-trafficking task forces and committees. It's very good that you have these committees established, but apparently they're not getting enough money and they're not being very active. They are particularly concerned, they make the allegation that your government did not adhere to your own sentencing requirements, that when trafficking is investigated, individuals are get suspended sentences, or they're allowed to have, as I said before, the out-of-court settlements. Can you give us any statistics on how many people have actually been tried and had suspended sentences, and how many haven't? They also indicate...
One more minute, Ms. Geer.
They also indicate that efforts to prosecute are just not what they should be. So I'd appreciate if you could comment on this. You could give us some information and statistics so we can work on that. Now, I wanted to also address the issue of paragraphs 163 to 168 of your report, which respond to question 29 in our list of issues that deal with violence against and harassment of persons because of a perceived sexual orientation. It's our understanding that same-sex relationships are criminalized in your country, that many people are arrested because of their perceived sexual orientation, and they claim that they are abused in this context. Now, your report in 163 to 168 just says no, unfounded, unfounded, unfounded. Doesn't happen. We have general laws. Anybody who doesn't like what's happening can come in and complain. So my question to you is, can you give us some specific data? Can you tell us, particularly in the case of the murder of Eric Ohena Lembembe, Ohenalembembe, who was the executive director of the foundation.
Time is up, Ms. Geer.
Can you give us some clarification on the charges against him and the actual investigations that were taken? Was there any investigation of the claim that he was tortured before he was killed, and of the claim that his foundation has revealed a lot of other instances of abuse? Thank you.
Thank you very much. I have two questions which relate to Article 14 in the Convention. As we know, Article 14 sets out the state party obligation to provide redress, including rehabilitation, to victims of torture. And we have outlined these obligations more in detail in our General Comment 3. In the current list of issues prior to reporting that we submitted to the state party, we requested disaggregated statistics on victim redress, including compensation. However, in the state party report, there are no information on the compensation measures that courts or other public bodies have ordered and which torture victims or their families have actually benefited from since the entry into force of the Convention of the State Party. A further concern is that claims for compensation for injuries resulting from torture or ill treatment cannot be lodged in civil proceedings until the criminal court rules on the claimant's allegations, which make the claim obtaining difficult compensation given the lack of effective investigations. The committee also requested information and statistics on state-provided rehabilitation, reparation programs, and material, human, and budgetary resources dedicated to rehabilitating victims of torture. In his report, the State Party noted that civil society organizations operate trauma centers for victims of trauma that include access to doctors, psychiatrists, psychotherapists, and lawyers, and which sponsor social protection and awareness programs. This is very fine, except for the fact that it's a state party obligation to provide such programs. So my two questions is the state party taking actions to establish effective mechanisms of providing redress to victims of torture which do not depend on lengthy court rulings in criminal proceedings? And second, is the state party taking any actions to allocate resources to this field, that is, rehabilitation of victims of torture, possibly by supporting Trauma Center Cameroon financially? At this point, I would like to ask the rapporteurs if they have additional questions, and we start with Mr. Hani.
Thank you to the delegation for their patience. I have some additional questions to ask. First question. I'm somewhat divided because you issued a standing invitation to the Human Rights Council Special Procedures to visit your country on 15th December 2015. And in spite of that, the Special Rapporteur on the situation of human rights defenders has been requesting to go to your country since 2012, and the mission was postponed on several occasions. In 2015, after having extended that standing invitation, the visit doesn't appear to be planned. Could you give us some dates, therefore, to enable the Special Rapporteur to visit your country? And the Working Group on Arbitrary Detention requested a visit in January 2017 and is still waiting, as well as the Special Rapporteur on the independence of the judiciary, and this since April 2017. The special procedures addressed urgent action sometimes, and they raised cases and handed down opinions, particularly the Working Group on Arbitrary Detention. So I'd like to have a response from you and a commitment on the part of your country to uphold that solemn commitment. The second point in your paragraph, in your report, paragraph 122, you focus on the exceptional nature of pre-trial detention. But in the statistics that you have produced, you calculate things. You say that there are 59% of inmates and the remainder of convicted. So in practice, you have reverted the norm. According to the figures, the norm would be pre-trial detention and not the exception. And in these figures, there's a very worrying figure as to the number of children held. 674 children out of 800 odd. So over 80% of children held in detention are in pre-trial detention and have not yet been convicted. So this is even worse for children. What measures do you intend to take to revert that situation and to come back to the norm which you assert yourself in the State Party report? There's another point on deaths in prisons and the statistics Annex 6 which you provided. Thank you for all of the details. There are two incidents that are of concern to the victim. 115 deaths in prison in over a 6-month period. In other words, 2 deaths per day. And here we're talking about so-called ordinary conditions, not the anti-terrorism fight. And this is a worrying figure. And the second point of concern is that in the statistics you give the dates, the details, but you also provide the reasons. You have a sudden death, for example, but you don't actually make a link with the risk of torture, because a sudden death might be as a result of torture. Do you order autopsies for each suspected death or suspicious death in detention facilities? As to the struggle against terrorism, Mr. Touzé mentioned this issue in detail, and I have 2 points to raise once again on the anti-terrorism fight. First of all, the weakening of legal safeguards. Basically, these legal safeguards have disappeared. They've collapsed, particularly the renewable custody period upon the authorization of the ministry involved. And so there's a risk of a pre-trial detention and arrest that could go on forever. So what explanations can you give us there? And what measures do you intend to take to put an end to this trend? And this is something which exists in your legal and in your criminal system. Now, another point now, based on some allocations which mention the presence of foreigners, particularly US officers. Now, of course, this information didn't make a direct link with interrogations, but could you give us some information about that? Could you confirm or deny the presence of foreign military officers surrounding the secret detention centres, where unfortunately torture is practiced according to the allegations made available to our committee? The participation of the military now, and just to come back to what Ms. Belmire said, training, Article 10 of the Convention and Article 11, so the systematic review of interrogation techniques. The participation of the military in these operations, in maintaining peace and in running detention centres, but also as part of the fight against Boko Haram, are a real problem. Is the military staff trained about the principle that a higher order cannot justify a legal act of torture? Very often the police are informed, but are your soldiers informed about the provisions of the Convention? And this applies to training and to interrogation techniques. The military and the army have been set up to protect the people against foreign risks. And when there is an internal risk, they take part in operations involving the police and in the prison operations in detention facilities. A question was raised by Mr. Touzé on enforced disappearances and the allegations of extrajudicial executions. Do you order any autopsies? Do you have enough forensic lawyers in Cameroon to undertake that work? And are healthcare staff trained to detect and document acts of torture in accordance with the Istanbul Protocol? I'd like to raise another point which has to do with fragile, if you will, populations. Ms. Geer mentioned this, as well as Ms. Raku. But we have persons with a disability. You yourselves have said that the number of persons with disability is very high in the country. Do you have any statistics about the number of persons with a disability who are held in detention, and what measures are taken to protect them? The committee has been made aware of a practice which would be a type of indefinite eternal detention for alienated persons. And when it comes to vulnerable or fragile persons, we've been made aware of a number of allegations concerning corrective rapes against LGBTI women. Does this practice exist, and what measures has the government taken to eliminate that practice? And if you've come across that in reality. Coming back to the independence of the judiciary, I know very recently you appeared before the Human Rights Committee. And unfortunately, the committee has not yet adopted its concluding observations. One of the issues, however, raised during the dialogue with you was on Article 64 of the Code of Criminal Procedure, which makes it possible for the intervention of the Ministry of Justice or the General Prosecutor to put an end to a criminal procedure. And here this directly hampers the system. Do you intend to amend that legal provision? We have some information flagging the systematic use of torture committed by the BIR, the Beer Brigade, and the DGRE, the Director General for External Research. Based on information from civil society, both brigades apparently have 120 secret detention centres under their responsibility. I'd like to end with one point, Chair, which I think is important. We mentioned FGM, but there are also other traditional harmful practices such as breast ironing, the use of children, etc. Indeed, things have developed on the legislative front, but what real actual measures is the government taking to combat those harmful traditional practices which run counter to the provisions of our convention? Thank you, sir.
Thank you, Mr. Hani. Madame Belmire.
Merci, Monsieur.
Thank you, Chairman, and thank you for allowing me to raise a number of additional questions. Deaths in detention and refugees. As to deaths in detention, the state party tells us that these deaths to a great extent are due to diseases. 567 cases between 2010 and 2014. Other reasons have been evoked: ill treatment, accidental deaths as by firearms as a result of a breakout, etc. Efforts have been made to reduce deaths in detention, and things need to be done to improve the health and hygiene, as well as providing water, doctors, nurses, transporting ill patients to hospitals. Even though resources are indeed limited, efforts need to be made to transport ill patients to a hospital. Now, the Ministry of Justice and the law governing that department means that the prison health falls under the Ministry of Justice or the Ministry of Health. We're not quite sure this, so clarification needs to be provided. Now, the other side of the coin is that those who are accused of supporting Boko Haram, who are placed in overcrowded, unhygienic prisons, particularly in Maroua prison, means that between 6 and 8 of them die every month. This is, of course, as a result of overcrowding, a lack of health and hygiene, a lack of medical treatment. Turning now to the issue of ill treatment, the state party says that prosecutions have been handed down, and that there have been persons convicted, and the penalties handed down vary between administrative detention. Very few punishment is meted out under Article 1 of the Convention. As to deaths as a result of torture, special reference is made of the behavior of the military vis-à-vis individuals who are supposed to have supported Boko Haram, and they passed away as a result of torture methods. And of course, the delegation of the state party can tell us whether all of this is true or not. I'll move on now to the refugee law. We have a law dating back to 2005. It focuses on the issue of refugees. The head of the delegation this morning talked about protecting refugees, as well as the drafting of a refugee plan, which took place this year, 2017. That plan was adopted in 2016 and still has to be implemented, and financing still has to be sought. Now, the head of the delegation, you did mention a number of institutional measures prior to 2016. decrees were adopted in 2011, which focus on the organisation and functioning of the Commission. This is in line with the recommendations issued by the treaty bodies, in particular the Human Rights Committee. However, there's a problem. There are shortcomings in this committee, in this institution, because very often refugees who are Nigerian civilians flee violence committed by Boko Haram, and the military expel these refugees by forced means, and they're accused of supporting Boko Haram. So there is a real problem here, and we would like to ask the state party to clarify the situation. Are these persons allowed to have access to the Office of the High Commissioner for Refugees? Thank you.
Thank you very much, Madame Belmire. I think this exhausts the questions from the committee. There were a lot of questions, and we will look very much forward to the replies from the delegation from Cameroon tomorrow at 5 o'clock. So thank you for your attention, and what did I say? 3 o'clock, yeah. Freudian slip, I'm sorry. 3 o'clock tomorrow, yes. And we wish you good luck, and we look very much forward to seeing you again tomorrow.
with a population of about 25,000, is situated in Goktinja Division, Northwest Region. Some few